Hello, hello, hello. This is Attorney Mike Graham coming to you from Chicago. As usual, I've got some good stuff. We've got Shaggy coming to court. It's pretty exciting. Let's get it started, shall we?
Mr. Neely.
Yes, sir.
Before the court, charged aggravated battery. And again, I don't want anybody to cancel me or anything over this, but I'm just going to read what the paperwork says. On a pregnant female. I'm not saying that a non-female can get pregnant. I'm just saying the paperwork says a pregnant female victim.
Your Honor, I don't have a lot ready, but Mr. Milton is here pro se, hoping to address that.
Our hero is bottom right, and he is a vibe.
That's on it. Is he on Zoom or is he on? Oh, Mr. Milton, there you are. What's happening today?
Oh, I forgot. I need to thank people. Mama RN sent this to me, Thrawn and Kathleen Estrada for today's stream.
It's on for trial confirmation, Mr. Sharp.
Seems prepared to confirm, Your Honor. One quick note I want to put on the record, though. So Mr. Milton did provide a witness list. The city's also provided one to him. Just wanted to point out that a couple of those witnesses are unknown to the city, and the nature of their testimony has not been provided. Maybe that'll be something that we receive before confirmation, but that could be an issue.
I did request a continuance at pretrial, and it appears I was denied. But
Okay, are you renewing that request now, or do you?
Is that something I'm able to do? Realistically, from what me and Matthew had spoken about, it seems that if I'm unable to articulate that I knowingly broke the law and I'm also able to defend myself in trial, then I'm not even able to accept the plea without lying to the courts, which doesn't seem like a smart move to me. So I think doing the trial is probably just the best idea.
I'm not sure I completely understand that.
Sure.
So
what question?
Mostly because it was stupid.
My question to you is, are you, this is on for trial confirmation. When both sides, I just heard from the city, look, we're ready to go to trial. And then you either say, yes, I'm ready to go to trial too, let's confirm to trial, and then you mentioned a continuance, and I'm asking, are you asking to move the trial and or continue the trial and I can discuss that with you, or you're ready to go to trial, and the trial is set for, let's see what day we have here.
28th and 29th.
The 28th and 29th. So you'll need to be here in person for that. You understand that?
No, I did not understand that.
But you do.
Okay, well, I will not be able to be there in person. I've just relocated north to deal with a warrant that I was told I needed to deal with from my DUI case.
So hang on just a minute.
Sure.
Stop talking about your case.
So the warrant, it looks like that's out of Skagit County. So are you up in Skagit County? Is that what you're saying to me? Someplace?
Yes, I will be here in probably the coming week. I've got a gas tank that's full right now. I'm working my way to handling it before my DUI hearing, I believe, is it was on the 26th. Now it's on the 7th of July.
The DUI case here in Thurston County.
As a matter of fact, I am. Yes, it is. Thank you so much. Thank you. Yeah, so the judge told me that I would look a lot better if I went and handled this before I had my hearing. So
Yeah, stop talking about your case, please.
I would, and that's what I'm doing.
Okay, so hang on just a second. Again, my computer's slow here.
Yep.
So do you have a court date set on that? How do you intend on taking care of that warrant out of Skagit County?
It appears to be a book and release they refuse to transport me for, so I have to drive up there myself and go and turn myself in and then get released, and then they'll set a court date for me.
Okay. And when do you plan to do that?
I'm working my way up there as of just a few days ago. The 15th, I made it just past Seattle.
Okay. So you're north of Seattle now?
Correct.
When do you intend to be back here in Thurston County?
That's a great question.
Thank you.
Yeah, sure.
That's subtle, but the judge's thank you was funny.
I guess I wasn't intending that I would have to.
Well, your court date in this DUI is, you're correct. That's July 7th. You can Zoom on that. But for jury trials, we don't do Zoom on jury trials. You actually need to be here in court for a jury trial.
Interesting. Okay. Okay. All right.
So you can be out of town and make your July 7th court date. That's not a problem.
Yeah.
But I don't want to confirm for trial if that trial is not going to happen because you can't be here. So that's why I'm asking these questions.
I appreciate that. Yeah. Thank you very much for helping me decide that's absolutely not optimal then. Yes, I would absolutely like to request
It's absolutely not optimal, Stoney. Thank you for clarifying.
for a continuance in that case.
Do you have a mailing address?
Yes. Yes, I do. I have two of them.
I want the most reliable one.
Okay. Okay. So the one in Anacortes that I will apparently be leaving behind to go back to deal with Thurston County would be 5207, but that seems irrelevant if I'm going back there, which it'll remain the 5213.
Okay, thank you.
Yep.
Did you get a text reminder of this court date?
I did not.
You have a cell phone where we could send you a text reminder of court dates.
I do. I've just gotten a new phone given to me by someone. And I don't know my phone number quite yet. Unfortunately, that makes me seem very less diligent than I'd like to appear.
Okay, can you?
That makes me less diligent than I'd like to appear. Oh, COVID, are you on here?
You provide that court date or that telephone to the court when you learn it?
Yes, absolutely.
We have a text number for you. It looks like the last four digits are 9283. Is that
Right.
Is that an old number that's no longer good?
It was stolen from me.
Okay. So I don't know if you've had conversations with any judges about what going to trial is like. Have you done any of that?
I've done a bit of research, but
No, I mean conversations with a judge in court here.
that would be a negative.
Okay. Have you ever conducted a trial before? Either any sort of trial, either jury or bench trial?
Negative.
Have you ever been present when a jury's selected for a jury trial? You'll have the opportunity to question them. And then at the conclusion of that question answer period, you can exercise certain challenges for jurors in certain circumstances or excuse them for no reason, which they call a peremptory challenge. You ever seen that process before?
I have not.
Do you go to law school? I'm assuming you're not a lawyer or didn't go to law school. Is that true?
I have not passed my bar exam, but I'm not aware that I'm required to do.
You don't say. I was guessing he definitely has passed the bar at some point. No, he's not a subset. He's just trying to be cool. It's not working. He needs help.
So
You're not, but I'm required to put all this on the record. So when you go to trial representing yourself, so then you don't come back later and say, well, I didn't get effective representation, which you're entitled to. And so then I want to basically you want to eliminate this as an issue on appeal. You see what I mean? So no, you're not required to, but I do want to get this on the record. So, you're going into this process with open eyes.
I appreciate that. Thank you.
You ever had training in the rules of evidence or rules of criminal procedure?
Not that I'm aware of.
And then you understand the attorney, Mr. Sharp, who represents the city of Lacey, is an attorney, does have training in the rules of evidence, is aware of the rules of criminal procedure, and been through more than a few trials. And so he would have a significant advantage over you if this case were to proceed to jury trial. Do you understand that?
If I was guilty, I would say yes, but I'm going to have to say I understand that he's more credentialed than me, but I don't understand the advantage.
Well, running a trial, I'll try and do my best to explain the advantage, and that is, running a trial is not a simple thing. It's kind of a complicated thing. And people who do it for the first time, it's a pretty steep learning curve there. When you walk into something you've never done before and have no clue about how the courtroom works or rules of evidence and criminal procedure, and you're going up against someone who has a very sophisticated knowledge of those things, that's going to be a pretty big advantage for the guy who's got that knowledge. Do you understand that?
Sure. I can get behind understanding that.
And you understand that you have the right to an attorney. I can appoint an attorney to represent you, who would be on a much more even playing field with Mr. Sharp.
I've been made aware that the public defense owns a YouTube channel, and I've witnessed that that particular person who was set to appoint me once upon a time benefits greatly from misrepresenting her clients, and I would rather not be misrepresented intentionally. But thanks.
Well, you're wrong about a few things.
That's all right.
First, she doesn't have a YouTube channel. We stream all these cases are streamed over YouTube through the court, not through her or anyone else. And I'm not even exactly sure who you're talking about. And so, but if that's a long way or your way of saying you're aware you have the right to be represented by an attorney and choosing not to take advantage of it, then we can go forward. Is that what you're telling me?
Yes, that is absolutely correct. It would not be in my best interest from my understanding. Thank you.
Okay. And that might be another point where we might agree to disagree
Has it occurred to you that your understanding sucks?
on. I think it would be to your advantage to take advantage of an attorney who frequently appears here and, again, has the same level of knowledge of the rules of evidence and criminal procedure, but you have the right to represent yourself. You do that. I just want to make sure you're doing that with open eyes. Do you understand that?
I appreciate you, Your Honor. Yes, I do understand.
So let's talk about a trial date then. So if you're not going to I'm not going to confirm for trial if you're not going to be here at your request. And so this time will be excluded from speedy trial calculation. I'm going to work on a date that makes,
you volunteered that.
That works for everybody when you can be here. So when do you think, again, I want an accurate date of when you're going to be back here, and we'll reset these dates right now.
Right. Let's schedule for perhaps late July if possible.
All right. And so we will do that. The clerk's going to find some dates here in just a minute. We're going to set, this is what's known as a confirmation date. We'll set a confirmation date. We'll also set jury trial dates. And now I want to talk to you a little bit about discovery and or witness lists. Okay. So one of the things about the rules of criminal procedure is that you have the right to call witnesses, whoever witnesses you wish to call, but you have some obligations too. You have to let the city know who they are and how to get a hold of them so they can interview these witnesses, just the same as the city has the obligation to tell you who the witnesses are going to be and how you can get a hold of them. Do you understand that?
Do you recall me providing you that list?
I'm not the prosecutor, so you didn't provide me to anything.
Oh, I handed it to you to hand off, and I handed it to Matthew Sharp as well.
Okay, so I can ask Mr. Sharp, and he wants to say something. I'll hear from him, Mr. Sharp.
Sure, I just thought it'd be helpful. I think the court does have a copy. I believe Mr. Miller brought 3 copies.
Okay, we might, but I don't. It's not the obligation to get it to me. It's the obligation to get it to you.
And we got it, and I'm looking at it right now, and he certainly lists several people that could be witnesses. Again, the city is not aware of what they would testify to, and as the court points out, there's not contact information for the city to conduct interviews ourselves.
So can you get that contact information, how to get a hold of these people you wish to call as witnesses?
And I can share, Officer Beavers is listed.
Wait a minute, Mr. Sharp. Okay, go ahead, Mr. Milton.
That is why I requested the pretrial continuance, and I rushed around to get the information. I know how to get a hold of them, but I don't have their private information. I only know how to get in touch with them, to tell them to appear and help me not get put in jail. So,
I don't know that, given your record, Mr. Milton, I tend to doubt that this is something, given the nature of the charge combined with your record.
my record. Oh, I didn't have one
Yeah.
before the defendant.
Right, that's my point. You don't have one. So I don't think you really need to spend a lot of time worrying about jail on a charge like this. That's my point. You don't have a record. You're right.
Sweet. That's awesome.
But you never know.
Right. Yeah, I won't pretend to.
That's awesome, Judge. Oh yeah, you're in Washington. You don't have a big prior record. You're not going to jail.
No.
Okay, so hang on just a minute. We're going to give you some, we're going to get some court dates for you.
Appreciate it.
And I want you to write these down because they'll get sent to you at the address.
Okay.
By the way, you're not driving now, are you?
Correct. I am not. I'm waiting
Great.
outside of the Planet Fitness to work
All right.
out.
I just want to make sure you're not driving. Believe it or not, sometimes people call in when they're
Another Planet Fitness member.
driving, and I always I make them stop.
I believe you.
Okay. Do you have something you can write down, Court?
There are a lot of great videos out there of crazy people at Planet Fitness. Maybe I'll do one day.
Dates with?
I am looking around for a pen right now, and normally I am not without one. But it appears now is a rare situation where I am. Ah, here we are.
Confirmation date.
Confirmation is 7:25.
Confirmation is July 25th at 10 a.m.
Okay.
And that for that hearing you can zoom into, but the jury trial is going to be
31.
July 31st and
Okay.
April 1st, or August 1st. April, where'd that come from? August 1st.
July.
So the 31st and August 1st.
All right. And are those both at 10 a.m. as well?
No, those will be at 9, and those you'll need to be in person for.
Don't worry, Tia.
Okay.
It gets worse.
Okay.
And then I'm going to rely on you to get that information to Mr. Sharp. You can get it to the court too, but it's more important that it gets to him. Any means that he can contact the witnesses that you intend to call.
Awesome.
Awesome.
Yeah, before we wrap up,
Mhm.
briefly.
Solid.
I guess, Mr. Milton, I trust you. You know how to get a hold of my office with that information. And please reach out if there's anything else to discuss with the case. But I wanted to bring up and ask the court about the possibility of if Mr. Milton would be interested in standby counsel. And I bring this up because at the beginning he had explained that there had been some negotiations and that the way he described the conversation, it sounds as though
I bring this up because I'd like to have a conversation with another human being that has cognitive function.
maybe he could benefit from having somebody he could ask some questions. For example, he's not apparently aware of the Alfred plea process. That may be applicable
he
and
is
maybe
not.
something he would be interested in. I am not in a position ethically to explain that to him. And I just want to make sure that he has the chance to ask for counsel, to have somebody on standby to ask questions of.
Mr. Milton, what's your response to all of that? Standby counsel is someone who doesn't represent you, but that just is someone you can, again, speak to, again, about the things that I spoke about, criminal procedure, rules of evidence, perhaps trial strategy, kind of a speaking library, if you will. Is that something you're interested in or no?
I will pass on it this time and enjoy the ride. Thank you.
Enjoy the ride, brother.
Okay, hang on just a minute.
The ride to jail. Well, if you're in any state other than Washington, perhaps.
Okay, and again, I'm just looking at your witness list here, Mr. Milton. Witness number 5 is this handwritten, someone named Repa, R-E-P-A.
Yeah, right.
Witness number 6 is just Shaggy. And so you're going to need to be a little bit more specific than that, provide, actual names and contact information. Do you understand this?
Sure. As soon as I go and get all of this information that I would never ask for somebody from a personal level, then I will be sure to inform the courts of the detailed information.
Okay, hang on just a minute.
And obviously,
Oh no, he's going to have to invade Shaggy's personal space now. That's what he's trying to tell the judge. Of course, they all have fake names because they're like street names. They're probably dealers and such. I don't know if these people are going to be good witnesses. I'm just saying.
Officer Evers is listed there, Your Honor, but the city knows how to contact her, so we're not worried about that.
And you're going to be responsible for making sure these folks show up too.
Okay.
All right. That's it for today. Notice your next court date will get sent to you at the Boulevard Extension Road. When you get a phone number or you remember your phone number or figure it out, then let the court know what that is. We'll also send you text reminders.
Okay.
But again, I'm going to repeat these just so you know, on the 25th at 10 a.m. and then on of July, and then the 31st of July and the 1st of August at 9 a.m. And the 31st and the 1st, you'll need to be here in person.
Okay. In person. Thank you, Your Honor.
You're welcome. That's it for today. I'm sorry?
Oh, have a nice one.
Thank you. You too.
Heck yes.
Heck yes.
And so,
If you bring a lawyer and your lawyer is saying everything you're saying, you would be in jail.
In the charge. Really? In a possession of an authorized blank or forged driver's license.
Y posesión de una licencia falsificada o en blanca sin autorización.
I understand he's been given copies of his paperwork and advised of his rights.
Entiendo que se le dio copia del papeleo y se le notificaron sus derechos.
Based on his application, I find he does qualify. I'm going to go ahead and appoint the public defender to represent him.
Según su solicitud, determino que califica y le asigno al abogado de oficio para que lo represente.
Deputy, criminal history?
22 domestic, 21 reckless, no valid.
Okay. Bond set 2,500 on the DUI.
La fianza son 2.500 en manejar bajo los efectos del alcohol.
1,000 on no valid driver's license.
1.000 por no licencia de conducir válida.
5,000 on the fraudulent driver's license.
5.000 por la licencia fraudulenta.
Court date is July 17th at 9 o'clock.
Su audiencia es el 17 de julio a las 9 en punto.
Buena suerte.
Buena suerte.
You got a question?
Oh, preguntas.
La licencia que yo ando es de Honduras. La licencia que yo ando es de Honduras.
The driver's license that I have with me is from Honduras.
Okay. I mean, I don't know why they charged him with unless it was changed. I don't know. That's a new charge for me.
Sí,
Yeah, they've
no,
been doing it with the
In
Jamaicans.
that case.
es un nuevo
They've been
cargo
doing it with the
para mí.
Jamaicans.
No sé qué decirle.
They've been doing that with Jamaicans too.
Yes, sir, for the last 2
So
weeks.
if they present a Jamaican driver's license, which is legitimate, they're charging them with fraudulent driver's license?
Yes, sir, been doing it for 2 weeks.
No, I agree they can't drive on it here, but I don't know that it makes it fraudulent here.
I'm telling you, they've been doing a minimum of 2 weeks strong. You probably got one today. I just didn't read them.
Do I have one, sir?
Yes, Your Honor, you have one that I'm going to be representing shortly.
Your Honor, may the interpreter be excused?
Yes, I appreciate you. Thank you, Giovanni.
Thank you, Your Honor.
All right, is this Mr. Wells? All right. Mr. Gunner, you represent Mr. Wells?
We represent on the 20 case, and I'm going to appear in a limited capacity for the first hearing.
Gotcha. Mr. Wells, before the court, charge of criminal use, personal identification, fraudulent use of a credit card, grand theft, and failure to appear on a pretrial conference for burglary. You understand those charges?
Yes, sir.
There's the register off the top of it. All right, Mr. Wells, your attorney is present on the criminal use of personal identification. Bonds $2,500. Fraud use of a credit card is $2,500. The grand theft is $2,500. Judge Register has held you without bond on failure to appear. Your court date is going to be July the 13th at 9 o'clock. Good luck, sir.
I step to your right.
Can you hear him? Sir, did you
Can you hear your attorney?
Sir? Went out of the jail on Friday. I got some stuff to tell you, all right? I'll see you in a couple days. All right.
State your name, sir.
RJ Thompson.
Mr. Thompson, before the court charges possession of counterfeit driver's license and possession of counterfeit license plates. Oh, plates.
Was it a soft set? We might have a soft set.
All right, sir. I understand you've been giving copies of paper.
I don't know anybody else who uses counterfeit license plates. I haven't seen this yet. Well, I haven't seen all of it. I've seen a little bit of it.
Paperwork and advise of your rights. Is that true?
You got a copy of your paperwork?
Yes, sir.
Were you,
Okay. Sir, what would you like to tell me about Mr. Thompson?
Your Honor, I'm appearing on behalf of Mr. Thompson, Kyrie's Cruz on behalf of the defendant.
What do you want to tell me about Mr. Thompson before I set a bond?
Your Honor, Mr. Thompson has no criminal record. He's in a similar situation. He has a valid Jamaican driver's license. He was yet charged with a fictitious driver's license. I anticipate that charge is eventually going to be dismissed. Secondly, he just purchased a motor vehicle. The persons are trying.
This guy's got the Jamaican market in Bay County locked up. He is the Jamaican fly lawyer right here.
To get the correct documentation to me. Once I have those documentations, I'll be coordinating with the state to see whether or not they're interested in proceeding with the charges. At this time, based on his history, I'd ask the judge, the court to set a bond ROR or a pre-trial release if the court deems that is necessary.
Deputy, criminal history?
shows no history with no social to confirm.
Pre-trial release, court dates July 13th at 9 o'clock. Thank you, Mr. Cruz. Thanks, sir.
Thank you, Honor.
Step to your right. Come on. State your name.
Anthony Miller.
Mr. Miller, you're fully court on a pay-to-pay fine for resisting officer without violence that was originally in front of Judge Grammer. You understand that, sir?
Yes, sir.
Judge Grammer sentenced you to 15 days in the Bay County Jail, but you may purge out upon payment of $500.
Yes, sir.
Step to your right to the T. When the green light comes on, you'll sign. Next. State your name.
Melody, all liberties.
So, Vidis, you're fully court on a violation of probation for perjury. You understand that charge, ma'am?
Yes. Yes, Your Honor.
I understand you'll be giving copies of paperwork and advise of your rights. Based on
Yes,
the
Your Honor.
application, funds you do qualify. I'm going to appoint the public defender to represent you. Your bond's been set at $5,000. Your court date is June 28th at 1:30.
I'm sorry?
Your court date is June 28th.
Next
Okay.
Wednesday.
Okay, thank you.
Hold on one second. Oh, you got it.
Did you say you're gonna appoint me a public defender? Did you say you were gonna appoint me a public defender?
Yeah, yes, ma'am.
Oh, I thought I had waited for that.
Somebody filled out the application for you.
For a public defender? No, I even have the notice to defendants who don't want to hire. No, I asked, if you want to join me, we can join together.
Okay, so you don't want a public defender?
No, sir. No, thank you. No, you're. I'm good.
Okay.
I don't have anything to argue.
No,
Please
no
step up to
reason
the
though.
right.
All right, dummy. Then I
I'm
won't
sure
put
they won't mind.
State your name.
Williams.
Ms. Williams, before the court on violation of pretrial release for domestic violence battery. You understand that?
Yes.
I understand you've been given copies of paperwork and advised of your rights. That's true?
Got a copy of your paperwork?
Oh, yes, I do.
All right. Colleen, you represent Ms. Williams?
Yes, Your Honor. I represent her in her pending felony case before Judge Clark. Just met with her yesterday before she was arrested.
Okay.
I was just out yesterday, so I met with her. This is all is what I'm saying, Your Honor. But we would ask, the lowest bond possible, and I realize there may be revocation coming in Judge Clark's division. We can certainly address it.
No, there's going to be a revocation coming in Judge Clark's division today.
Fine, Your Honor.
Yeah.
Yeah.
Okay. Yeah. Yeah. We got an administrative order that allows us to keep right along doing what we do. So the circuit judges have encouraged us to take that off of the plate.
Yes, sir. I understand.
All right, Ms. Williams, on the violation of pretrial release, bonds $5,000. Court date's going to be June 23rd at 8:30, and I'm signing a revocation of release in 23/1977. Good luck, ma'am.
I'll be in touch
Thank
with
you.
Step to your right.
Thank you, Ms. You have a good one.
This face TV. State your name.
Carmen.
Ms. Franklin, you're for the court charge of battery. You understand that charge? I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, I find that you do qualify for the services of the Public Defender's Office. I'm going to go ahead and appoint the Public Defender to represent you. Any question about that?
No, sir.
Deputy, criminal history, Ms. Franklin?
He shows no history.
All right, ma'am. I'm going to release you on what's called pretrial release. You report to the pretrial release office before 9 o'clock tomorrow. No contact directly, indirectly, or through a third party alleged victim. You understand that?
Yes, sir.
Good luck, ma'am.
All right.
Court date's
Step
gonna
to
be
your right.
June 23rd at 8:30.
Sir, Miss Bennett declined to make your acquaintance today.
Ms. Bennett has made my acquaintance dozens of times.
Yeah, I
in the
know.
past. Why did she decline today? What did you say to
It
her?
could be you. It could be me.
No, I don't think it's, well, I'm going to go with you. If it's between the two of us, if we're the only two variables, the number of times that I've dealt with Miss Bennett, well, I don't know. That's probably not true either. You're right. It could be you or me. It could be either one of us. That's fair. Bond's $1,000. I'll see her Friday at 8:30.
Are you doing the probation?
I didn't want to, but I will if you make me. What's her?
Yeah, go ahead. I already wrote it down.
I'll just put it on. That's
Yeah,
why she didn't come. What's the
It was
case number?
grammar, I thought. 23, 24, 32 M.
I think it was that week I was doing it for Judge Grammer. What's that? Okay. All right. Is this Ms. White?
Yes.
Ma'am, before the court charge of possession of meth, possession of paraphernalia. You understand those charges, ma'am?
Yes, I do.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes.
All right, ma'am. Based on your application, I find that you do qualify for the services of the Public Defender's Office. I'm going to go ahead and appoint the Public Defender to represent you. Any question about that?
Sorry, I didn't hear what you said.
You got a PD now. I'm giving you a Public Defender. Deputy, criminal history, Ms. White?
You have a domestic in 21 and a paraphernalia. That's it.
All right, bond set at $5,000 the meth, $1,000 the paraphernalia. Random UAs directed by your court. Court date's going to be July 13th at 9 o'clock. Good luck, ma'am.
Step to your right.
I don't know why.
Next.
Everybody's doing things. They're too hard.
Next.
It's a little
Red
ridiculous.
X-Men.
It's heavy.
State your name.
Pinckney, you're for the court for the violation of probation for possession of cocaine, possession of MDMA in front of Judge Overstreet. You understand that charge?
Yes, sir.
Judge Overstreet, in his infinite wisdom, is where you held without bond. Your court date is July the 5th at 9 o'clock. Good luck, ma'am.
All right, step to your right. No bond. To your right. Next.
Okay, thank you.
Step right here. Face the TV. State your name.
Javier Rubio.
Mr. Rubio, you're for the court. Charge of domestic violence with battery. Do you understand that charge, sir?
You understand your charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Excuse me?
You got a copy of your paperwork?
Yeah,
Were you advised of your rights today?
Yes.
All right, you've indicated you're going to hire your own attorney or represent yourself. Is that how you're going to proceed?
I was going to hire an attorney.
Okay. Deputy, come on up here.
Just a controlled substance out of Texas in 17, that's it.
Bond set 2,500. Court date's going to be June 23rd at 8:30. No contact directly, indirectly, or through a third party to alleged victim. Good luck, sir.
All right, step to your right to the T. Next. Step on the X, sir. State your name.
Mr. Douglas, before the court, charge driving license suspended or revoked and a violation of probation for criminal mischief and disorderly intoxication. You understand those charges?
Yes, sir. Yes.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, I find that you do qualify for the services of the Public Defender's Office. I'm going to go ahead and appoint the Public Defender to represent you. Any question about that?
Yes, sir.
Bond set 2,500 on the DWLSR. Court date's going to be June 23rd at 8:30. You're held without bond on the DOP. Your court date is June 28th at 1:30.
Step to your right. Next. Red X, sir. State your name. Yep. Your name?
My name is Mark Bilbo.
Bilbo, before the court, charge leaving the scene of an accident. You understand that charge?
Yes, sir, I understand that. I never felt the damage on it, sir. I wasn't trying to leave, but anyway. Yes, sir, I understand that's right.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
I never felt the damage.
I have copies of the paperwork and advice of my rights.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the Public Defender to represent you, so you have an attorney now. Any question about that?
So I couldn't hear you.
He gave you an attorney.
Okay, yes, sir, thank you.
Deputy, criminal history?
Shows no history and they don't have a social to compare.
Where are you from, Mr. Gilbert?
South Carolina.
Okay. All right, sir.
Bond's
Bond's 2,500. Court date's Friday, June 23rd at 8:30. Good luck, sir.
Yep, you're gonna get copies. Step to your right. You're fine. State your name.
Mr. Folsom, before the court, charge domestic violence with battery. You understand the charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
All right, sir. Based on your application, I found that you, if I can get to it, you qualify for the services of the Public Defender's Office. I'm going to go ahead and appoint the Public Defender to represent you. Any question about that?
Yes, sir.
Deputy, criminal history?
State of Georgia, battery to Leo, threatening Leo with harm, 19. VOP 19, 18, false name to Leo, possession of a weapon by a felon VOP, 16, trespass, shoplifting, resisting VOP times 3, and a trespass and a criminal mischief in 15.
Yeah, he's a bad boy.
Okay. All right, Mr. Folsom, bond set at $5,000. No contact, directly, indirectly, or through a third party alleged victim. Court date's June 23rd at 8:30.
Step to your right, sir. Next. Yep, come on. Step on the X. Face the TV. There you go. State your name.
Mr. Eldridge, you're before the court charged with battery. You understand that charge?
Yes.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yeah.
All right, sir. Based on the application, I find that you do qualify for the services of the Public Defender's Office. I'm going to go ahead and appoint the Public Defender to represent you. So you have an attorney now. Any question about that?
No.
Deputy, criminal history?
Just the battery last year and that's it.
Bonds 2,500, no contact. Alleged victim, court date is June 23rd at 8:30. Good luck, sir.
All right, step to your right. Wait. Next. State your name, sir.
Mr. Neely,
Yes, sir.
before the court, charged with aggravated battery. And again, I don't want anybody to cancel me or anything over this, but I'm just going to read what the paperwork says. On a pregnant female. I'm not saying that a non-female can get pregnant. I'm just saying the paperwork says a pregnant female victim. Also before the court on a failure to appear for an arraignment on a possession less than 20 grams of marijuana and paraphernalia. You understand the charges?
Yes, sir.
Okay. I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
All right. Ma'am. I know. Y'all live in the same place?
Well, that's my sister right there.
Hey, I'm talking right now. Chill out, Mr. Neely. Let me talk to her. Hey, y'all stay apart while this is pending? Can you stay apart while this is pending?
Yes.
Okay.
Yeah.
All right.
I don't know.
No, you don't talk to me about dropping charges, but you talk. I'll tell you. You're fine. You're fine. You talk to the state attorney's office. Yeah. You talk to the prosecutor. So you know where that is? It's like a block and a half. Yeah, we'll talk to you after. Just stick around for a few minutes. We'll give you the 411 on what to do if you want to go talk to somebody about it. All right, but you understand I've got to order for y'all not to have contact while this is pending. Okay. All right, Mr. Neely.
Yes, sir.
You're charged with a felony because yeah, it's a felony because your sister's pregnant. That makes it a felony. So you need to be aware.
Yep.
Yes, Your Honor. Okay, we're on the record now in 3 files. We have 2 files that are set for probation violation arraignments today. It's file number 216235 and 6237. And then we have set for a status conference in file number 236512. Mr. Brown, can you tell me how we're going to proceed in these files today?
Your Honor, we are going to ask for adjournments on probation violations because I believe they are based on underlying facts that constitute current charges. As far as the status conference goes, I believe this is on the delivery charge. I thought we had another status conference set for the 6th already. I could be wrong, but I would like to have that one adjourned to speak with Mr. Chris a little bit further.
Michigan.
He also is currently being charged with, I believe, larceny Retail fraud first degree. I am not the attorney on that matter. So there's a lot going on that we just need to review a little more.
Okay, that's a separate file.
It is.
And that one's not noticed for hearing.
No, it is not.
But a lot going on.
That matter is currently district court, hasn't been bound over yet. That's district court case 23-41844 FY3.
Okay. Mr. Chris, did you have a question? I saw you with your hand raised.
Yes, sir. As far as everything goes on this, I've been the one that's come in and talked to you guys. I've not tried to stay hid from you. I'm just trying to make sure that I can pay my fines and fees and keep working and taking care of my medical disabilities right now until you sentence me whenever we go to trial or to court.
Your Honor,
if you look at the evidence.
Well, Mr. Chris, let's not get into the evidence.
Yeah, stop talking about your case, please.
Okay?
Yes, sir.
Okay, so first of all, what the court's going to do on the 2 probation violations, the court's going to enter not guilty pleas on Mr. Chris' behalf with regard to all alleged violations in both files. And the court will set those out about 90 days to allow Mr. Chris, his lawyer and prosecutor, to discuss both the current new felony file and the new charges of the 4th file in district court. And in terms of bond, I'm going to assume bond's already been set in the felony file. It looks like that's a $5,000 cash or surety bond.
It was, Your Honor. I believe that bond was posted. It was revoked based upon these violations.
Okay. So is there an argument, Mr. Brown, you want to make regarding bond?
Your Honor, Mr. Chris was going into it. He's suffering from a lot of health issues. He advised me he recently had all of his teeth pulled just 2 or 3 weeks ago. He has some breathing issues that he's dealing with. He is currently employed. He is also attending something called the Clubhouse at CMH that is helping him essentially with daily living and different skills like that.
He's currently employed? That is a freaking miracle.
It's my understanding he cannot read or write, so that's a very essential thing for him. I would just ask the court to consider some of those issues.
Judge, people would oppose any amendment or granting reduction in bond. This is a situation where, as evidenced by the alleged probation violations, Mr. Chris can't follow the court's order, so it chooses not to do so. He commits crimes when he's out on bond, which is the newest offense right now. And it's a circumstance where convicted, especially with the prisoner in possession of contraband or attempting to bring contraband into jail, he's looking at consecutive sentencing under MCL 768-781. I think those are all valid reasons as to why the bond was set. In fact, it realistically would have been set higher.
Okay, so with regard to bond, you said he did post in the felony file?
You did post that, didn't you, Mr. Chris? It was revoked.
Yes, I've posted both of my bonds, Your Honor.
Okay, so I can't do anything with the district court file. Obviously, I don't have any jurisdiction over that. The felony file, the court's going to order that bond be reinstated. I think it's a $5,000 cash or surety bond. I think that's sufficient to ensure Mr. Crisp's appearance at future court hearings, and I think that bond was appropriate to set. So the court will reinstate that bond on the felony file. As to the probation violations, the court's satisfied that that bond on the felony file and whatever the bond is going to be or is on the district court file headed our way is sufficient to protect the interests that the court has with regard to the probation violation file. So the court's going to set those as personal recognizance bonds of $500 each. And then again, the court will set this file for a hearing I'm sorry, when I say this file, I mean the felony file 236512 for a hearing in about 30 days. Mr. Giel is obviously not here, but Mr. Brown, I don't know, through MIBC, what I'd like to see is one attorney.
That is generally the way it is. I don't know what happened.
So can you talk to Mr. Giel and get that reassigned?
Yes.
Okay. And then if that's up, the court will set that for hearing at the same time as these three files as well. Mr. Brown, anything further I can address from your side today?
No, Your Honor.
Mr. Rowland?
No, Judge, thank you.
Okay. All right, Mr. Crisp, that's all for today. If you have further questions, you can talk to Mr. Brown, your attorney, okay?
Well, what just happened?
You can talk to Mr. Brown, he'll explain it to you, all right?
I'll tell to you. Thank you, sir.
Thank you.
Just relax. Just relax.
It's alert, like alert the building's on fire, sir.
Okay, yes, gotcha. All right, we're on the record in People versus Alert, case number 23.
Oh, good Lord.
6520, 6521, 6522, and 6523. The record should reflect Mr. Alert is present here.
Got one here for Pride Month
today, along with prosecutor Mr. Rolla. And we're set for status conferences in these files today. Mr. Alert, I believe last year we had your previous counsel, Mr. Seeger, withdrew from representation.
This is correct, Your Honor, and I actually was going to ask the court for a 90-day adjournment. I am continuing to talk with a new attorney because I feel like we can get a favorable resolution in all four of these files. So that would be my request, of course. And I do have a few questions.
This one, I don't know. This guy is just insufferable. That's all. He's just insufferable the whole time.
If you have a minute, sorry.
Okay, so it's been a month since Mr. Seeger withdrew.
Correct, sir.
So why do you need 90 more days?
Well, unfortunately, I've had two deaths in my life. One, my grandmother passed back in April, and the other, one of my best friends from high school, committed suicide a few weeks ago. At this present time, it's just been it's been a lot. So 90 days would be ideal. Now, with that being stated, I am talking to an attorney to get, representation, obviously, because I make too much to get public defense, and which I would prefer to retain my own counsel, of course. So that's my only request, Your Honor. At that point in time, 90 days should work for me, because at that point I'll be able to speak with my attorney and get the ball rolling, of course, because obviously we don't want to continue to wait, if you will. Mr. Rowland.
I'm glad to hear Mr. Alert's indicating he has income. There is a plea offer which would resolve all of his files, and it will not matter whether he represents himself or whether or not he gets other attorneys. It's not going to change the plea offer of the prosecution. His plea offer is as follows. File number 236520FH. He pleads to count one, financial transaction device without consent. We will dismiss his habitual offender second enhancement. In file number 236521, financial transaction device NSF check over $500. If he pleads to count one, we will dismiss the habitual second enhancement. As to file 236522FH, that is
throw him in the lockup with the guy top right, and this will resolve real fast.
12 counts of financial transaction device overcharging. If he pleads to counts 1 and 4, we will dismiss counts 2, 3, 5 through 12 and the habitual second enhancement. And as to file 236523FH, which is again 3 counts of non-sufficient funds checks over $500. If he pleads to count 1, financial transaction device, steal, use, retain without consent, people would dismiss counts 2 and 3 with habitual second as well. There is restitution total in all files currently of $14,073.65. As far as a 90-day adjournment, since this matter's already been adjourned 30 days, the people think at the most the court should consider 60 days, and that would be an outside number as far as further extensions. As to giving Mr. Alert the opportunity, he has to retain his own counsel, which is his right.
And then you said you had some other questions, Mr. Alert.
Yes, I do. So So to one of my bonds, I'm not allowed to speak or communicate with Mr. Ventil. However, I just learned that Mr. Ventil, not from my own doing, from a close friend up here, has opened a new flower shop and as well has retained all of my equipment that has been purchased. I am working with an attorney at this present time, and I wanted to make sure the court would be okay if I would continue to work with that attorney, because it will be turning into a potential lawsuit at that present time. And so I don't know if that would be a possibility.
I'm not sure what you're asking.
Oh, he's going full chili here.
You're saying you want to have contact with this individual?
I would not want to have contact.
He's right in the chili mold. This guy.
Bond states that I cannot, nor can I have anybody communicate with this individual. But with that being stated, within the new light of Mr. Ventil opening a flower shop, I would kindly ask the court to allow me to communicate through my attorney at that present time to Mr. Ventil and his legal representation, due to the fact that there is a conflict of interest there from owning a flower shop to now.
At that time would conflict with the present time. I'm just saying, learn English.
Just opening up a whole new flower shop with all of my equipment that I own.
A whole new bar of chocolate. I think you just said a whole new bar of chocolate. I don't know.
Mr. Rolla, do you have objections on that?
Judge, obviously, as the court's well aware, even though there's a condition of no contact with this defendant, if the person who's allegedly representing us in the civil matter would be well aware that he would be allowed to communicate with any individual or court proceedings matters, and I think that's what he's asking about. I don't think the court needs to amend any condition, because I don't want to see, the people specifically do not want to see Mr. Oler trying to use that as an excuse to intimidate a witness. Otherwise, he'll be looking at additional 10-year felony charges of witness tampering or intimidation.
With that being said, Your Honor, I am no longer in the Oswego County range. I am within my bond limits within the state of Michigan. So at that present time, I agree with Mr. Rolla. I do not want to have any communication with anybody, especially from the note that you have seen from your assistant, Mr. Rook. I don't want to have any communication or contact at this point with anybody. And I just wanted to clarify that, because all it says in my bond conditions, I or nobody else should have contact through me. So if that would be okay with you,
I think you should have your civil attorney contact the court about that contact and notify the court.
It's just basically, and I can explain to you what it is. It's just basically a lawsuit and a cease and desist letter.
Yeah, I don't think we need to talk about the details, but if your lawyer in that civil matter wants to have contact with anybody involved in a bond condition, then that lawyer should contact the court.
Okay, because I wouldn't really consider it a bond condition, since it's not going to be a buddy conversation. It's just a
We don't care what you'd consider it, Jagoff.
Proceeding, but I understand for sure, Your Honor.
Okay. Did you have any other questions?
With that being stated, I'm very well known within the community, in a good and a bad way, if you will. And since I am no longer within the Oswego County realms, would it be possible from here on out to go into a virtual courtroom into Zoom? Just because there has been some circumstances where I've had some black numbers call me to intimidate me, if you will. I don't know who those are. Those individuals won't, introduce themselves. I do have unlisted phone number now, so I don't have a situation with that. But, to give the court a little bit of background, I got up at 5 a.m. to get up here by 10 a.m. because I'm no longer up in the northern part, I'm in the lower part of Michigan.
No one cares.
And my address is current as well.
No one cares.
Where our criminal proceedings are in person, if you're having problems, like you indicated in your letter, as well as what you're saying here today, then I think you need to contact law enforcement or the prosecutor's office to address those. It's not something that I can or would consider as a reason not to come to court.
The problem is the voices. I'm very familiar with the voices. I don't want to name names because I don't specifically know, but it's been community members all the way up to law enforcement who have contacted.
Oh, as bad as this is, It actually gets worse.
Check me on block numbers.
Then you need to contact the Attorney General's office in Lansing to report it. If you think somebody under the color of law is doing something improper,
No worries.
then I understand why you wouldn't want to go to local law enforcement, but then the remedy is through the Attorney General's office.
Okay, yeah, I have no problem. I just wanted that well on the record so you knew about that, because for me it's extremely uncomfortable, to come back here because people know me very well. Like,
For me, it's extremely uncomfortable. We don't care. You're a defendant. You've been charged with something. Resolve it or show up to court.
and I apologize for bringing it up, but your wife knows me very well from my flower shop, so that was the other question.
I don't know how to put this, but I'm kind of a big deal.
Would you classify that as a...
Oh, yeah. He wants the judge to recuse himself because his wife went to his flower shop in a town with like probably one flower shop. Oh, sweet Jesus.
As a conflict of interest, since your wife is used to my flower shop, and the same thing for Mr. Rolla with for the Veterans Day. I don't know if that would be a conflict of interest or not, so...
Sure, and it's a small town, so myself and my family have contacts in the business world with lots of people that sometimes come before the court. If you feel that that's a basis for disqualification, then you're certainly free to file that motion, or once you retain counsel, they can do that as well.
Right, and these are just questions right now, so once I do retain my attorney, I can bring these up. So thank you very much for your time, Your Honor, of course.
And so, excuse me, I think in answer to your question, you're going to need to continue to appear in person for hearings. That's at this point, I'm not hearing enough of, I guess, validation of your concerns.
Okay, terrific. And I'll bring my attorney, once my attorney is involved, I'll bring it up to him, them, he, she, they, and then they'll bring it up with you and Counselor Rolla, of course.
Correct. So the court will set this for hearing in 60 days. I'll give you 60 more days. That would be a total of 90 from the last hearing.
Okay,
that's a reasonable amount of time for you to be able to retain counsel. And then at that time, we'll send you notice of the date and time of that hearing. Once you do retain an attorney, that person should file an appearance here with the court.
Yes, they will, for sure. No worries, of course. Yeah, no worries. And then just to clarify, I obviously don't want my address displayed on YouTube, of course. The address you have is the current one from, okay, terrific.
You can confirm that off the record with their clerk.
Yes, it's
downstairs.
Well, I mean, thankfully we don't have your address on YouTube because nobody wants it. But we do have your glorious failure on YouTube.
Okay, terrific. I will do so. I mean, it hasn't changed, so.
Okay. Mr. Roll, anything else that we need to discuss? Okay. Thank you, Mr. Alert. That's all for today.
Awesome. Thank you, Ron.
Well, there you have it. That was Kathleen Estrada's fault. I thought I'd save the most annoying for last. It was all good stuff. Oh, yes. Thank you, Jason. Thank you, Allie. You guys are sweet. We had all sorts of crazy. We had, what do we have there? We had the guy who we had the dude in Washington who told the judge he's totally gonna have Shaggy on his witness list. No other information, just Shaggy. You can't contact him, but he's gonna be there and he's gonna back up my story. We had what? We had Judge Van trying to choke out the quote from the information. Where it specified a pregnant female. We had Bigfoot who absolutely did not know what happened, and then we had that guy. That's quite a group. Thank y'all for coming out. I appreciate it. I'll see y'all soon.